If you are a naturalized American citizen, you have always believed one thing with absolute certainty, that your citizenship is permanent and irreversible, that once you raised your right hand, took the oath of allegiance, and became an American, that status could never be taken away. For decades, that belief was not just comforting, it was factual. Naturalization meant crossing a finish line that could never be moved backward. But as we move through 2026, that fundamental assumption is being challenged in ways that would have been unthinkable just a few years ago. The Trump administration's immigration enforcement strategy has shifted from focusing on borders and new arrivals to something far more unsettling: internal review. Old naturalization cases are being reopened. Files that sat untouched for decades are suddenly under scrutiny, and new legislative proposals are emerging in Congress that could make stripping away citizenship easier than ever before in modern American history. For millions of naturalized citizens who already built their lives, raised families, bought homes, and contributed to this country for years or even decades, this moment feels like the ground shifting beneath their feet. The question that was never supposed to be asked is now being whispered in immigrant communities across the nation. Is my American citizenship truly permanent, or could it actually be taken away? Across the United States today, there is a quiet but unmistakable sense of anxiety spreading through naturalized communities. People who thought their immigration journey ended years ago are suddenly wondering if they need to review old paperwork, if a forgotten detail from an application filled out decades ago could come back to haunt them, if their status in this country is as secure as they always believed it to be. And what makes this moment so alarming is not just one policy change or one new law. It is the combination of multiple shifts happening at the same time, all pointing in the same troubling direction. Internal enforcement targets are rising dramatically. New legislation is being proposed to expand the grounds for denaturalization, and the entire philosophy of how immigration agencies approach citizenship is changing from passive enforcement of clear fraud cases to active, systematic review of millions of old files. So what exactly is happening in 2026? Who is really at risk? What do these changes mean for the 26 million naturalized Americans living in the United States today? And most importantly, what should you do to protect yourself and your family? These are the questions we are going to answer today, step by step, separating facts from rumors and helping you understand the reality of this unprecedented moment in American immigration history. To break all of this down properly, let me introduce myself. Hi, I'm Daniel Carson, and welcome to U.S. Policy Updates, where we explain the latest immigration policy developments in a straightforward, factual, and easy to understand way. If you have ever felt anxious about new policy changes, confused by complicated legal language, or worried about how shifting enforcement priorities might affect you or your family, you are in the right place. In this video, we are going to examine the sweeping changes to denaturalization policy unfolding in 2026, changes that are shaking the foundation of what naturalized citizenship has always meant in America. We will go through it carefully, looking at what is actually happening behind closed doors, what the real numbers show, and what the long-term implications could be for immigrant communities across the country. And to really understand why this issue is creating so much fear and uncertainty, we first need to look back at what American citizenship has always represented and why the protections surrounding it were designed to be so strong in the first place. For generations, American citizenship has been regarded as one of the most powerful and secure legal statuses anywhere in the world. Once a person completed the long, often exhausting immigration process, passed rigorous background checks, lived as a lawful permanent resident for the required number of years, studied American history and civics, and finally stood before an immigration officer or judge to take the oath of allegiance, that moment represented absolute finality. It was not just a legal milestone, it was a profound transformation. It meant you were now American in every sense of the word, with all the same rights, protections, and permanence as someone born in the United States. A U.S. passport was more than just a travel document. It was tangible proof that the years of paperwork, interviews, fees, waiting periods, anxiety, and uncertainty were finally over for good. Naturalized citizens built their entire futures around this promise. They purchased homes knowing they would never face deportation. They started businesses confident that their legal status was secure. They enrolled their children in schools, planned for retirement, and integrated deeply into their communities, all with the absolute belief that their place in America was now permanent and protected by law. That understanding was not just an emotional comfort, it was backed by powerful legal safeguards written directly into federal statutes. Under existing law denaturalization, the legal process of revoking someone's citizenship was designed to be extraordinarily difficult for the government to pursue. The burden of proof was intentionally set at one of the highest levels in American law. Federal prosecutors had to demonstrate with clear and convincing evidence, a standard just below the criminal standard of beyond a reasonable doubt, that an individual obtained citizenship through willful misrepresentation, deliberate concealment of material facts, or outright fraud during the naturalization process itself. The key word in that legal standard is willful. That means intentional, purposeful, knowing. The law made a critical distinction between someone who deliberately lied or used false documents to gain citizenship and someone who simply made an honest mistake on a complicated application form, memory gaps about travel dates from 20 years ago, translation problems for people filling out forms in a second or third language, clerical errors or minor inconsistencies in old paperwork were never supposed to qualify as grounds for stripping away citizenship. The system was built to recognize human imperfection and to reserve denaturalization only for the most extreme cases involving serious fraud, terrorism, war crimes, crimes against humanity, or direct threats to national security. And for decades, the numbers reflected that philosophy. Denaturalization was used so rarely that it barely registered in official government statistics. Over roughly an 8-year period from 2017 through 2025, the total number of denaturalization cases filed by the Department of Justice across the entire United States was only about 120 cases total. That averages out to fewer than 20 cases per year in a nation of more than 330 million people with tens of millions of naturalized citizens. That extraordinarily low number showed just how exceptional and rare the process was intended to be. It was a last resort legal tool used only when the evidence of fraud or serious wrongdoing was absolutely overwhelming and undeniable. Naturalized citizens lived their lives with the confidence that this protection was real and permanent. They believed, because the law told them so, that once they became American, no one could take that away. Their children grew up as Americans, their grandchildren were born as Americans, and the family's connection to this country was supposed to be permanent across generations. But now, for the first time in many decades, that carefully constructed framework of protection is being tested and challenged in fundamental ways. And what makes 2026 such a critical turning point is that the challenge is coming from two directions at once. On one side, internal enforcement policies within immigration agencies are pushing to dramatically increase the number of denaturalization cases being reviewed and prosecuted. On the other side, new legislation is being proposed in Congress that would expand the legal grounds for revoking citizenship beyond anything current law allows. And the combination of these two forces, aggressive enforcement plus broader legal authority, is what has millions of naturalized Americans deeply concerned today. To understand the scale and significance of what is unfolding, we need to look at the specific changes taking place inside U.S. Citizenship and Immigration Services, the agency responsible for processing naturalization applications and maintaining citizenship records. According to multiple reports from immigration attorneys, former USCIS officials, and investigative journalists at outlets like the New York Times and NPR, internal guidance has been circulating within the agency since early 2026 with a clear and unprecedented directive. Field offices across the country are being instructed to actively search through old naturalization files and identify potential denaturalization cases that can be referred to the Department of Justice for prosecution. This is not passive enforcement, waiting for obvious fraud cases to surface on their own. This is proactive, systematic review of files that were approved and closed years ago, sometimes decades ago. Officers are reportedly being encouraged to look for inconsistencies, discrepancies, or red flags in old applications that might suggest fraud, misrepresentation, or concealment of material facts. And once a case is flagged as potentially problematic, it gets referred to DOJ attorneys who then decide whether to file a formal lawsuit seeking to revoke that person's citizenship. But what makes this shift truly alarming is the numerical target that has apparently been set. According to sources familiar with the internal guidance, USCIS field offices are expected to generate between 100 and 200 denaturalization referrals every single month. Let that number sink in for a moment. Between 100 and 200 cases per month means somewhere between 1,200 and 2,400 potential denaturalization cases per year. Compare that to the historical average of fewer than 20 cases annually, and you are looking at an increase of roughly 60 to 120 times what was considered normal just a few years ago. This is not a small adjustment. This is a complete transformation in how the system operates. What was once an extraordinary legal remedy reserved for the most egregious violations is now being systematically pursued as a routine enforcement priority. And the implications of that shift are profound, not just for the individual cases that might be affected, but for what it says about how the government now views naturalized citizenship itself. To put this in even sharper perspective, consider the math. There are approximately 26 million naturalized citizens living in the United States today. If USCIS is targeting 2,200 to 2,400 referrals per year, and if even a fraction of those referrals turn into actual lawsuits and denaturalization proceedings, we could be looking at thousands of families thrown into legal battles over their citizenship status. Families who believe their immigration story was finished decades ago. Families who have lived as Americans, contributed to their communities, paid taxes, raised children, and never imagined they would have to defend their citizenship in court. And this enforcement push is not happening in isolation. It is being paired with new legislative efforts that would make denaturalization even easier to pursue. In January 2026, a bill called the SCAM Act, short for the Stop Citizenship Abuse and Misrepresentation Act, was introduced in Congress by Senator Eric Schmitt of Missouri in the Senate and Representative Tom Emmer in the House. The legislation quickly gained support from key figures in the Trump administration and a number of Republican lawmakers who argued that existing denaturalization laws were too narrow, too difficult to enforce, and contained loopholes that allowed serious fraudsters and criminals to keep their citizenship simply because their conduct occurred after naturalization rather than during the application process. The bill was introduced in direct response to several highly publicized cases, most notably a large-scale benefits fraud scandal in Minnesota involving members of the Somali immigrant community. Federal investigators allege that dozens of individuals used fraudulent documents and false identities to illegally obtain government benefits over several years, stealing millions of dollars from federal programs. Some of those individuals had already become naturalized U.S. citizens by the time the fraud was discovered. Under current denaturalization law, however, prosecutors faced significant legal obstacles in pursuing revocation of citizenship because the fraud occurred after the individuals had naturalized, not during their original immigration applications. Supporters of the Scam Act, including Senator Schmidt and organizations like the Federation for American Immigration Reform, pointed to cases like this as clear evidence that the law needed to be changed. They argued that if someone commits serious fraud against the United States government after becoming a citizen, or if they hide criminal activity or terrorist affiliations that should have disqualified them from citizenship in the first place, there must be a mechanism to revoke that status. From their perspective, citizenship is a privilege, not an entitlement, and people who abuse it or obtained it dishonestly should not be allowed to keep it simply because enough time has passed. So, what exactly does the Scam Act propose to change? The bill would expand the legal grounds for denaturalization in several significant ways. First, it would explicitly allow citizenship to be revoked based on any material fraud committed against the United States government, not just fraud during the naturalization process. This means benefits fraud, immigration petition fraud on behalf of others, tax fraud, or other serious deceptive conduct, even if it occurred years after someone became a citizen, could potentially serve as a basis for denaturalization. Second, the bill would make conviction of an aggravated felony a standalone ground for revoking citizenship. Aggravated felonies, a category defined in immigration law, include serious crimes like murder, rape, sexual abuse of a minor, drug trafficking, firearms trafficking, large-scale fraud, and many others. Under current law, committing an aggravated felony after naturalization does not automatically threaten citizenship. Under the Scam Act, it could. Third, the legislation would codify and expand denaturalization grounds related to national security and organized crime, including membership in or affiliation with terrorist organizations, engagement in espionage or foreign intelligence activities, and participation in drug trafficking cartels or transnational criminal enterprises. Fourth, and perhaps most controversially from a legal perspective, the bill includes language designed to clarify and potentially broaden the types of evidence the government can use to prove fraud or misrepresentation. Supporters say this is a technical clarification to make enforcement more practical. Critics warn it could lower the evidentiary bar and make it easier to pursue cases based on circumstantial evidence or old inconsistencies, even without clear proof of intentional wrongdoing. Finally, the Scam Act would impose a 10-year statute of limitations on certain denaturalization actions tied to post-naturalization conduct. This means if someone commits a qualifying offense within 10 years of becoming a citizen, the government could initiate proceedings to revoke citizenship. This represents a significant departure from the traditional understanding that citizenship becomes even more secure over time. Taken together, these provisions would represent the broadest expansion of denaturalization authority in modern American history. And when you combine this proposed legislation with the aggressive enforcement posture already being implemented inside USCIS, the picture becomes deeply troubling for millions of naturalized citizens. This is not just theoretical. Early evidence from 2026 suggests that the shift in enforcement priorities is already producing results. According to reports from immigration attorneys and court filings, the Department of Justice has already begun filing denaturalization lawsuits at a noticeably higher rate than in previous years. While comprehensive statistics for 2026 are not yet available, attorneys practicing in immigration law report seeing more cases in the first few months of this year than they typically saw in entire previous years combined. Some of these cases involve individuals accused of hiding serious criminal histories, gang affiliations, or terrorist connections during their naturalization applications. Those are the kinds of cases that have always qualified for denaturalization under existing law, and few people would dispute that such conduct warrants serious consequences. But attorneys also report seeing cases that involve much more ambiguous circumstances, minor inconsistencies in old paperwork, differences between what someone listed on a green card application 15 years ago and what appeared on a later citizenship form, short trips abroad that may not have been perfectly documented, benefits applications with errors that were later corrected. In the past, these kinds of issues would typically be resolved administratively, perhaps with a fine or a requirement to correct the record. But in the current enforcement environment, with pressure to meet monthly referral targets and with political leadership emphasizing toughness on immigration fraud, the standards for what gets flagged and referred for prosecution may be shifting. What was once considered a minor discrepancy or an honest mistake could now be reclassified as potential evidence of material fraud. And once a case is referred to the Department of Justice, the legal process takes on a life of its own, regardless of whether the person ultimately did anything intentionally wrong. This is the fear that is spreading through naturalized communities today. Not necessarily that large numbers of people will ultimately lose their citizenship, but that the process of being investigated, defending yourself in court, hiring expensive attorneys, and living under the cloud of potential denaturalization for years could become a reality for thousands of families who did nothing wrong except make ordinary human mistakes on complicated forms filled out long ago. To truly appreciate how dramatic this shift is, it helps to look at the historical data more closely. From 2017 through 2025, the total number of denaturalization cases filed by the Department of Justice was approximately 120. That works out to an average of about 15 cases per year. In 2017, there were 11 cases. In 2018, there were 16. In 2019, the number rose slightly to 24 as the Trump administration, during its first term, began emphasizing denaturalization as a priority. But even in that peak year, 24 cases nationally was still an extremely small number in a country with tens of millions of naturalized citizens. Those cases were also highly selective. They typically involved individuals with serious criminal convictions, proven connections to terrorist organizations, or clear evidence of identity fraud using stolen documents. These were not borderline situations or ambiguous cases. They were clear violations where the evidence was overwhelming. But now, with internal targets reportedly set at 100 to 200 referrals per month, the scale is changing dramatically. If those targets are met, we could see between 1,200 and 12,400 cases referred annually. Even if only half of those referrals result in actual lawsuits, that would still represent a 40-fold increase over historical averages. And if the Scam Act passes, expanding the legal grounds for denaturalization even further, the number of people potentially affected could grow even larger. Mainstream news outlets, including the New York Times, NPR, and Reuters, have all reported on these internal USCIS targets and the broader shift in enforcement philosophy. This is not speculation or rumor. It is confirmed by multiple independent sources, including former government officials, immigration attorneys who are seeing the impact in their practices, and investigative reporting based on internal agency documents. And what makes the situation even more concerning is that when enforcement agencies operate under numerical expectations or quotas, the nature of the cases being pursued can begin to change. There is pressure to find enough cases to meet the monthly targets. That pressure, even if unintentional, can influence how officers evaluate files, how they interpret inconsistencies, and how aggressively they pursue leads. The risk is that the focus shifts from catching the most serious fraud to simply finding enough cases to reach the goal. It is important to emphasize that under current law, and even if the Scam Act passes, the government still has to prove its case. Denaturalization is a civil legal process that requires filing a lawsuit in federal court. The government must present evidence. The naturalized citizen has the right to legal representation, the right to challenge the evidence, and the right to defend themselves. And the government must meet the burden of proving, with clear and convincing evidence, that citizenship was obtained through willful misrepresentation or that the person committed one of the specific qualifying offenses under the law. That legal standard is designed to be difficult to meet. It is supposed to protect people from having their citizenship stripped away based on minor errors, misunderstandings, or innocent mistakes. And in theory, that protection still exists. The government cannot simply change its mind about someone's citizenship years later because of a new policy preference or a different political administration. There must be actual evidence of wrongdoing. But here is where the practical risks come into play. When immigration officers are reviewing files that are 10, 15, 20, or even 30 years old, those files were often completed on paper, not in digital databases. People filled out forms by hand, sometimes in a second or third language, often without the help of lawyers. They were asked to recall addresses from years earlier, list every international trip they had ever taken, provide employment histories spanning decades, and answer dozens of other detailed questions, all from memory. In that context, small inconsistencies are almost inevitable. Maybe someone listed a slightly different date for when they entered the country on one form versus another. Maybe they forgot to mention a short trip to visit family abroad because it seemed unimportant at the time. Maybe they misunderstood a question about employment history and listed only their main job, forgetting about a brief period of part-time work. Maybe there was a translation error or they were confused about what information was required. None of those situations involves intentional fraud. They are honest mistakes, the kind of imperfections that occur when human beings try to navigate a complex bureaucratic system. But in an enforcement environment where officers are actively looking for red flags and under pressure to meet referral targets, those same innocent discrepancies can be reinterpreted as evidence of potential deception. A forgotten trip abroad could be seen as an attempt to hide something. A date inconsistency could be treated as a sign of document fraud. An incomplete answer on an employment question could be viewed as concealment of material information. And once a case is flagged and referred to the Department of Justice, the burden shifts. The naturalized citizen now has to defend themselves, often at enormous emotional and financial cost. Immigration attorneys specializing in denaturalization cases report that legal fees can easily run into tens of thousands of dollars, sometimes more than $50,000 or even $100,000 for a complex case that goes through multiple stages of litigation. The process can take years. During that entire time, the person and their family live under a cloud of uncertainty, not knowing if they will be allowed to keep their citizenship or if they could ultimately be stripped of their status and potentially face deportation to a country they left decades ago. Even if the person ultimately wins and keeps their citizenship, the damage to their life, their sense of security, and their trust in the system can be profound and lasting. Children watch their parents go through years of legal battles. Spouses worry about whether the family will be torn apart. Communities see their neighbors targeted and become afraid that they could be next. The psychological toll is immense, and it extends far beyond the individuals directly involved in any specific case. To understand the deeper human impact of what is happening, imagine for a moment what it feels like to be a naturalized citizen in 2026. You came to the United States 20 or 25 or 30 years ago. You went through the entire immigration process, followed every rule, waited in long lines, submitted to background checks, paid thousands of dollars in fees, studied for your citizenship test, and finally, after years of patience and hard work, you took the oath and became American. That moment was supposed to be the end of your immigration journey, the final chapter, the permanent resolution. You built your life around that promise. You bought a house, you started a business or built a career. You raised children who were born here as Americans and know no other country. You paid taxes, voted in elections, served on juries, volunteered in your community. You became, in every meaningful sense, fully American, and you believed, because the law told you so, that your citizenship was permanent and could never be questioned again. Now, in 2026, you hear news reports about internal enforcement targets. You read about legislation in Congress that would expand the grounds for denaturalization. You see stories about people whose citizenship is being challenged based on old applications filed decades ago. And you start to wonder, did I make any mistakes on my paperwork all those years ago? Was there any information I forgot to include or any question I might have answered incorrectly? Could something I did not even think was important at the time come back to threaten everything I have built? That feeling, that sense of vulnerability and uncertainty is spreading through naturalized communities across the United States. It does not matter if you have lived as a law-abiding citizen for 30 years. It does not matter if you have deep roots in this country and have never had any legal problems. The mere existence of these new enforcement priorities and legislative proposals is enough to make people feel insecure about their status in ways they never imagined they would have to worry about. Immigration attorneys report that their phones are ringing constantly with concerned questions from naturalized citizens. People want to know if they should review their old files, whether they should be worried about traveling internationally, whether updating their address with a government agency or applying for benefits could trigger additional scrutiny, whether they need to hire a lawyer just to make sure everything in their record is in order, even though they have done nothing wrong. This is what is known as a chilling effect. Even without mass denaturalizations actually happening, the psychological impact of knowing that your citizenship could potentially be reviewed and questioned is enough to change behavior and create widespread fear. People become reluctant to engage with government agencies. They hesitate to assert their rights or ask for services they are entitled to. They avoid international travel to visit family abroad because they worry about what might happen when they try to re-enter the country. They feel like they are living on permanent probation, as if their membership in American society is always conditional and could be revoked at any moment. And there is a deeper, more troubling dimension to this as well. When naturalized citizens begin to feel that their status is less secure than that of people born in the United States, it creates what many immigration advocates describe as a two-tier system of citizenship. On one side, you have natural-born citizens whose status can never be questioned or taken away, no matter what they do. On the other side, you have naturalized citizens who may always live with the possibility that their citizenship could be reviewed, challenged, or revoked based on old paperwork or past conduct. That distinction strikes at the heart of what American citizenship is supposed to mean. One of the most fundamental principles of the naturalization system has always been that once you become a citizen, you are American in every sense of the word, with exactly the same rights and protections as someone who was born here. There is no second class. There is no asterisk next to your citizenship. You are simply American, period. But when denaturalization becomes a systematic enforcement tool rather than a rare legal remedy, that principle begins to erode. Naturalized citizens start to feel like they are permanently different, permanently vulnerable, permanently less secure than their natural-born neighbors. And that feeling of being treated as a conditional member of society, even decades after taking the oath of allegiance, fundamentally undermines the promise that America has made to generations of immigrants. As these changes unfold, they are sparking intense debate across the political spectrum. Supporters of the increased enforcement and the Scam Act legislation argue that these measures are necessary, overdue, and fundamentally about protecting the integrity of American citizenship. They point to real cases of fraud, criminal activity, and abuse of the immigration system as evidence that current laws are too weak and too difficult to enforce. From this perspective, citizenship is a privilege and an honor that should be reserved for people who earn it honestly and who uphold their obligations to the United States. If someone obtained citizenship through deception by hiding a serious criminal history, by concealing gang affiliations or terrorist connections, or by using fraudulent documents, then they never deserve to be American in the first place. And if someone commits serious fraud or violent crimes after becoming a citizen, demonstrating that they have no respect for American law or values, then there should be a clear legal mechanism to revoke that status. Supporters also argue that the vast majority of naturalized citizens have nothing to worry about because they obtained their citizenship honestly and have lived as law-abiding members of society. The enforcement efforts, they insist, are narrowly targeted at genuine bad actors, not at ordinary immigrants who made minor mistakes on old forms. Senator Eric Schmidt, in introducing the Scam Act, emphasized that the bill is about correcting past mistakes in the system and ensuring that people who never should have been granted citizenship in the first place are held accountable. Organizations like the Federation for American Immigration Reform have praised the legislation and the increased enforcement as long overdue steps to restore integrity to the naturalization process. They argue that for too long the government has been unwilling or unable to pursue denaturalization, even in clear cases of fraud, creating a perception that citizenship, once obtained, can never be challenged no matter what someone has done. That, they say, is wrong and undermines public confidence in the entire immigration system. But critics see the situation very differently. Immigration rights organizations, civil liberties groups, and many immigration attorneys warn that these changes pose serious dangers, not just to people who committed fraud, but to thousands of innocent naturalized citizens who could be swept up in an enforcement system operating under numerical targets and expanded legal authority. From this perspective, the problem is not the goal of catching genuine fraud. Everyone agrees that serious fraud should have consequences. The problem is how broadly the enforcement net is being cast and how easily the definition of fraud can be stretched when agencies are under pressure to meet monthly referral quotas. Critics point out that when immigration officers are expected to find 100 to 200 cases per month, the incentive structure changes. There is pressure to flag cases even when the evidence is ambiguous, to interpret inconsistencies as signs of fraud even when they might simply be honest mistakes, and to refer cases for prosecution even when a reasonable person might conclude that no intentional wrongdoing occurred. This concern is amplified by the language of the Scam Act, which uses broad terms like material fraud and affiliation with terrorist organizations without clearly defining what those terms mean in practice. What counts as material? How much contact qualifies as affiliation? These are judgment calls that prosecutors and immigration officers will make case by case, and history shows that such discretion is not always applied evenly or fairly. Civil rights advocates also raise serious concerns about unequal enforcement. Will certain immigrant communities be targeted more aggressively than others? Will people from particular countries, regions, or ethnic backgrounds face more scrutiny simply because of where they were born? The Somali community in Minnesota, for example, has already been singled out in public discussions of the Scam Act. While the fraud cases that inspired the legislation were real and serious, advocates worry that the entire community could now be viewed with suspicion, leading to disproportionate enforcement actions against Somali Americans, even when individual cases are ambiguous or weak. This fear is not hypothetical. Throughout American history, immigration enforcement has often been applied unevenly, with certain communities bearing the brunt of aggressive policies based on prevailing political sentiments or stereotypes. Critics warn that the same pattern could emerge with denaturalization, creating a system where naturalized citizens from certain countries or backgrounds live under greater threat than others, even though the law is supposed to apply equally to everyone. At a deeper level, opponents argue that these changes fundamentally undermine one of America's core promises, that anyone, regardless of where they were born, can become fully and permanently American. If naturalized citizenship becomes conditional, subject to review and revocation years or decades after the oath is taken, then it is no longer truly equal to the citizenship held by people born in the United States. That creates exactly the kind of two-tier system that the naturalization process was designed to prevent. Immigrant advocacy organizations have also pointed out that the United States already has legal mechanisms to punish fraud and serious crimes. If someone commits benefits fraud, they can be prosecuted criminally and face fines or imprisonment. If someone commits an aggravated felony, they serve their sentence under the criminal justice system. The question these critics raise is whether those offenses should also result in the loss of citizenship, a penalty that goes far beyond the crime itself and strikes at a person's fundamental identity, belonging, and connection to the only country many of their children have ever known. It is also important to recognize that denaturalization is not happening in isolation. It is part of a much broader and more aggressive immigration enforcement agenda that has been unfolding throughout 2026 under the Trump administration. This administration came into office with explicit promises to dramatically increase interior enforcement, not just at the border, but throughout the country, targeting individuals who are already living in the United States. That interior enforcement push has included a significant increase in immigration detention, more workplace raids, expanded cooperation between local law enforcement and federal immigration authorities, and intensified scrutiny of benefit applications and fraud investigations. Denaturalization fits into this larger picture as one piece of a comprehensive strategy to review, investigate, and when deemed appropriate, remove individuals who the administration believes should not be in the country, even if they have already been granted the highest form of legal status available. From the administration's perspective, this represents a course correction after years of what they view as lax enforcement and insufficient attention to fraud and abuse within the immigration system. They argue that previous administrations were too reluctant to pursue tough cases, too willing to overlook inconsistencies, and too focused on processing applications quickly rather than ensuring accuracy and integrity. But from the perspective of immigrant communities, this broader enforcement context makes the denaturalization push feel even more threatening. It is not just one policy change. It is a fundamental shift in the government's approach to immigration, moving from a focus on who can enter the country to an equally intense focus on who is allowed to stay even after completing the legal process and becoming a citizen. This shift has profound implications for how naturalized Americans see themselves and their place in this country. For decades, the implicit social contract was that if you followed the rules, completed the process, and became a citizen, you were permanently protected, you were fully American, with all the security and belonging that status entails. Now, that contract feels uncertain. The rules seem to be changing after the fact, and millions of people who thought their immigration journey was over are realizing that they may never truly be free from the possibility of having their status questioned. If you are a naturalized U.S. citizen reading this or watching this video, it is completely natural to feel anxious or uncertain about what all of this means for you and your family. But it is crucial to remember several important facts that can help you navigate this moment with clarity and preparation rather than panic. First, the vast majority of naturalized citizens are safe. The changes unfolding in 2026 are primarily targeted at cases involving serious fraud, significant criminal conduct, or national security threats. If you obtained your citizenship honestly, if you went through the process in good faith, if you have lived as a law-abiding member of society, you are almost certainly not at risk. The legal standard for denaturalization remains high. The government still has to prove its case with clear and convincing evidence. And even with increased enforcement, successful denaturalizations will still be relatively rare compared to the total population of naturalized citizens. That said, being informed and prepared is always better than being caught off guard, especially in a changing policy environment. Here are some practical steps you can take to protect yourself and reduce uncertainty. First, gather and preserve all of your old immigration records. This includes your naturalization certificate, your certificate of citizenship if you have one, copies of your green card, visa documents, passport copies, arrival and departure records, and any correspondence you received from USCIS or other immigration agencies over the years. If you still have the actual application forms you filled out for your green card and citizenship, keep those as well. If you applied for government benefits at any point, keep copies of those applications and any supporting documents. Having a complete, organized file of your immigration history can be invaluable if questions ever arise. It allows you to quickly verify information, explain any inconsistencies, and demonstrate that you have been transparent and honest throughout your time in the United States. Second, review your immigration history carefully and honestly. Think back through your entire immigration journey. Were there any complicated issues during your green card application or citizenship process? Any questions you were unsure how to answer? Any information you might have provided that was incomplete or unclear? Any gaps in your travel history or employment record? Any interactions with law enforcement, even minor ones? If you remember anything that could potentially be viewed as problematic or ambiguous, it is worth consulting with a qualified immigration attorney now before any issues arise. An attorney can review your complete file, assess your specific risk level, help you understand what information is in government records, and advise you on whether any proactive steps should be taken to clarify or correct old information. Third, be thoughtful and strategic about international travel. If you have a complex immigration history, if there were any issues or complications during your naturalization process, or if you have any concerns about how your case might be viewed in the current enforcement environment, consider consulting with an immigration attorney before making plans to travel abroad. While you absolutely have the right to travel as a U.S. citizen, re-entry to the United States can sometimes trigger additional questions or scrutiny, especially in an environment where border officers are being encouraged to look more carefully at naturalized citizens' files. This does not mean you should never leave the country. It simply means being aware and prepared, understanding what documents you should carry, and knowing how to respond if questioned. Fourth, stay closely informed about policy developments. Monitor reliable news sources for updates on the Scam Act and other immigration legislation. Follow immigration law websites and organizations that track policy changes. Sign up for alerts from reputable immigrant advocacy groups. Understanding what is actually happening, as opposed to rumors or exaggerations, will help you make better decisions and avoid unnecessary panic. If the Scam Act passes or if other significant policy changes occur, you want to know about it quickly so you can assess how it might affect your specific situation. Fifth, do not ignore official notices. If you ever receive any communication from USCIS, the Department of Justice, or any other government agency regarding your citizenship status or immigration history, take it seriously immediately. Do not assume it will go away on its own. Do not try to handle it without professional help. Contact an experienced immigration attorney right away before the deadline to respond expires. These cases move quickly once they start, and having legal representation from the very beginning can make an enormous difference in the outcome. A qualified attorney can evaluate the strength of the government's case, develop a defense strategy, gather evidence on your behalf, and represent you in all interactions with government officials and in court if necessary. Sixth, and finally, know your rights. If you are ever questioned by immigration authorities, border officers, or other government officials about your citizenship or immigration history, you have important constitutional rights. You have the right to remain silent if you are unsure how to answer a question or if you are concerned that your answer might be used against you. You have the right to speak with an attorney before answering questions. You have the right to refuse consent to searches of your home, vehicle, or belongings without a warrant, although you should always be polite and respectful in asserting these rights. You are not required to provide access to your electronic devices or passwords without legal authority. Educate yourself and your family members about these rights so that everyone knows how to respond appropriately if they are ever approached or detained. These practical steps will not eliminate all risk or uncertainty, but they can significantly reduce your vulnerability and help you feel more in control during a time when many naturalized citizens feel anxious and powerless. The goal is not to live in fear. The goal is to be prepared, informed, and proactive in protecting your legal status and your family's security. As we move deeper into 2026 and toward 2027, the debate over denaturalization and the permanence of naturalized citizenship is likely to intensify rather than fade away. The SCAM Act is still making its way through Congress. It has to pass both the House and the Senate and then be signed into law by the president. That process could take months, and the legislation could be amended, delayed, or even defeated along the way, depending on political dynamics, public pressure, and advocacy efforts from immigrant communities and their allies. But even if the SCAM Act does not pass in its current form, the underlying enforcement trend is clear and unlikely to reverse in the near term. The Trump administration has made aggressive interior enforcement a central priority, and denaturalization is now a key component of that strategy. The internal targets within USCIS for identifying and referring cases are already in place and are being implemented. Early data from 2026 suggests that referrals are indeed increasing, and unless there is a major shift in political leadership or policy direction, that trend is expected to continue. For the 26 million naturalized citizens living in the United States today, this represents a profound and unsettling moment. The promise that citizenship is permanent and secure, a promise that has been the foundation of the American immigration system for generations, is being tested in ways that would have been unthinkable just a few years ago. The sense of finality and belonging that naturalization was supposed to provide is being replaced with uncertainty and fear. And even without large numbers of people actually losing their citizenship, the psychological and emotional impact of knowing that your status could potentially be questioned is enough to fundamentally change how millions of people feel about their place in this country. This is also a moment that raises profound questions about American values and identity. What does it mean to be American? Is citizenship a permanent bond that, once established, can never be broken except in the most extreme circumstances? Or is it a conditional status that can be reviewed and revoked years or decades later based on shifting political priorities and enforcement philosophies? The answers to these questions will shape not just immigration policy, but the very nature of American society and the promise America makes to those who come here seeking a better life. Immigrant advocacy organizations are mobilizing to fight these changes. They are working to defeat or significantly amend the SCAM Act. They are documenting cases of unfair or discriminatory enforcement. They are providing legal assistance to naturalized citizens facing denaturalization proceedings. They are educating communities about their rights and helping people understand how to protect themselves. And they are making the case loudly and persistently that naturalized citizens are Americans, period, and deserve to be treated with the same permanence and respect as anyone born here. At the same time, supporters of increased enforcement are also mobilizing. They are highlighting cases of fraud and serious criminal conduct to build public support for tougher measures. They are arguing that citizenship must mean something, that it cannot be obtained or kept through deception, and that the government has both the right and the responsibility to correct past mistakes and revoke status from people who never deserved it in the first place. This debate will play out in Congress, in courtrooms, in the media, and in communities across the country over the coming months and years. The outcome is not predetermined. It will be shaped by political will, public opinion, advocacy efforts, legal challenges, and the voices of millions of naturalized Americans who are now being forced to defend the permanence of their own citizenship. If there is one message to take away from everything we have discussed today, it is this: stay informed, stay prepared, but do not let fear control your life. The changes happening in 2026 are real and significant. They represent a troubling shift in how the government approaches naturalized citizenship. But the legal protections that have existed for decades are still in place. The burden of proof is still on the government, and the vast majority of naturalized citizens who obtained their status honestly and have lived as law-abiding Americans have strong legal grounds to defend their citizenship if it is ever questioned. Being aware of these developments, understanding your rights, keeping good records, and knowing when to seek legal help are all sensible and appropriate responses. But allowing yourself to live in constant fear, to stop engaging with your community, to avoid travel or interaction with government agencies out of panic, is neither necessary nor healthy. You are American. You earned that status through years of patience, hard work, and commitment to this country. And that status deserves to be treated as permanent and secure. At the same time, it is crucial to recognize that this is a moment that demands attention and engagement. If you care about the future of immigration in America, if you believe that naturalized citizens should be treated as fully and permanently American, if you think these enforcement changes are unjust or dangerous, then make your voice heard. Contact your elected representatives in Congress. Support organizations that are fighting to protect immigrant communities. Share accurate information with friends and family. Vote for candidates who share your values on these issues. Democracy works when people participate, and naturalized citizens have just as much right and responsibility to participate as anyone else. If you found this explanation helpful and want to stay updated as the SCAM Act and other denaturalization policies continue to develop throughout 2026 and beyond, I strongly encourage you to subscribe to this channel and turn on notifications. Things are moving quickly and new developments are emerging almost weekly. We will be here to break down every major change clearly, factually, and in a way that helps you understand exactly what is happening and what it means for you and your family. Thank you for taking the time to watch and educate yourself on such a critically important issue. These are challenging times for immigrant communities, but knowledge and preparation are powerful tools. Stay informed, stay prepared, protect your rights, and remember that you are not alone in navigating these changes. I'll see you in the next update.